Get ready for the dictation. Start. Lord Phillips then considered the facts of the Christian Brothers case itself. In the context of vicarious liability, the relationship between the institute and the brothers had all the essential elements of the relationship between an employer and employees. The institute was subdivided into a hierarchical structure and conducted its activities as if it were a corporate body. The teaching activity of the brothers was undertaken because the local administration of the institute directed the brothers to undertake it. It was undertaken by the brothers in furtherance of the objective or mission of the institute. The manner in which the brothers were obliged to conduct themselves as teachers was dictated by the institute rules. The relationship between the brothers and the institute differed from that between employer and employee in that the brothers were bound to the institute not by contract but by their vows, and in that far from the institute paying the brothers were obliged to transfer all their earnings to the institute. Neither of these differences was material. Indeed, they rendered the relationship between the brothers and the institute closer than that of an employer and its employees. The relationship was therefore sufficiently akin to that of employer and employee to be capable of giving rise to vicarious liability. The three cases which I have discussed illustrate the general approach set out by Lord Phillips at paras 35 and 47 of the Christian Brothers case. It may be said that the criteria are insufficiently precise to make their application to borderline cases plain and straightforward, a criticism which might, of course, also be made of other general principles, also be made of other general law of tort. As Lord Nicholas observed in Dubai Aluminium at para 26, a lack of precision is inevitable given the infinite range of circumstances where the issues arises. The court has to make a judgment assisted by previous judicial decisions in the same or analogous contexts. Such decisions may enable the criteria to be refined in particular contexts, as Lord Phillips suggested in the Christian Brothers case at para 83. It is important, however, to understand that the general approach which Lord Phillips described is not confined to some special category of cases such as the sexual abuse of children. It is intended to provide a basis for identifying the circumstances in which vicarious liability may in principle be imposed outside relationships of employment. By focusing upon the business activities carried on by the defendant and their attendant risks, it directs attention to the issues which are likely to be relevant in the context of modern workplaces where workers may in reality be part of the workforce of an organization without having a contract of employment with it, and also reflects prevailing ideas about the responsibility of businesses for the risks which are created by their activities. It results in an extension of the scope of vicarious liability beyond the responsibility of an employer for the acts and omission of its employees in the course of their employment, but not to the extent of imposing such liability where a tortfeasor's activities are entirely attributable to the conduct of a recognizably independent business.